Now let's see if Judge McBurney will keep him on probation or revoke his remaining time. Don't forget to subscribe to this channel and like this video as we keep dropping great videos on this channel.
All right, let's get on the record, please. This is 19 SC 170465. It's State versus Xavier Evans. Mr. Evans is here in court with his lawyer, Mr. Rigdon. Ms. Dilligard is here for the state. And we are working through a probation revocation situation. And Mr. Evans, when I saw you last, based on what the state's recommendation was, you and your lawyer said, wait a minute, we don't necessarily want to go along with that. So maybe we'll have an evidentiary hearing instead, which you're entitled to. Sounds like between that point and today, you and your lawyer and maybe family members have talked some more, and it is now your preference, instead of me hearing more about the situation with the off-duty officer at that location, that you're going to stipulate. That doesn't mean you admit to having committed any crime, but you're going to stipulate that you were arrested in November for assault against a peace officer and aggravated battery of that peace officer. And then your lawyer will advocate for a particular sentence. I'm making the numbers up, but he'll say 1, and the prosecutor may say, no, it should be 3. And I'll hear from both sides and then let you know what I'm going to do. Does that describe what you think is going to happen?
Yes, sir.
Okay, then that's what we're going to do going forward. I'm going to ask Ms. Simpson to get us started by telling me how much time remains on Mr. Evans's sentence.
Judge, he has 4 years, 10 months, 15 days remain.
Thank you. And is the 19 SC case the only case you're aware of where Mr. Evans is on probation? Okay. All right. So Mr. Rigdon, I'm going to turn to you now. It sounds like Mr. Evans is stipulating to the fact that he was arrested in November of last year. I think he was arrested with his brother. Am I correct? I think I'm remembering the same incident. So he was arrested in November for assault and battery, aggravated assault and aggravated battery on a law enforcement officer.
Correct.
Okay. All right. You tell me what you want about Mr. Evans, his situation, and what you think an appropriate outcome is here.
As far as what I'm asking for is somewhere in the range of 24 months. We'd like him to be kept locally. I know Attorney Rockwell is handling the underlying charges that we're hearing today. Also, we'd like him here locally so that she can continue to work on his case.
Does it remain an unindicted case as far as you know?
Yes, Judge, it's still unindicted.
Okay, got it. Okay.
Judge, I'd also like to get him into some type of drug alcohol classes. That is, I think, at the root of this case. This was allegedly took place at a liquor store that kind of a vendor had been going on, and I think it's one of those situations, like probably many things that here before Your Honor, that untreated alcohol addiction is one of the root causes of this. So I'd like him to be able to go with that with the idea of getting better as opposed to just punishment time, Judge. I have spoken at this point extensively to his mother, who's here in the courtroom. I've spoken to his long-term romantic partner. He has a solid community network here. I know when he is released, he can go back to his job, which is being a mobile mechanic. I know that's what he was doing when all this occurred. So Judge, we think 5 is, we think revoking the balance is a little bit draconian here, and that's because he actually get into the fact that it seems like his brother was the more culpable partner. In fact, at first, my client gets so intoxicated, at first he basically ended up on the ground. His brother kind of jumped into this and really seemingly did a lot of damage. And then later I think it picked back up again, but considering he's not the sole author of this event, we'd ask somewhere around 24 months, Judge.
Okay. And I'm trying to pull the case up. Mr. Evans's brother is also in custody at this time?
He's bonded out at this point, Judge. He has no criminal record.
Okay, and so he didn't have a probation warrant that would keep him in. All right. So Xavier Evans, I see his case. it lists Ms. Rockwell as the attorney. That's shifted to someone?
On the underlying case, I'm here on the BOP. I just had a pretty good relationship with Mr. Evans and wanted to bring him in. We don't have any plans currently to shift. And I've been texting with Ms. Rockwell, Attorney Rockwell during this whole thing.
I thought you had said Ms. Steffo. I must have misheard you. So when you said Ms. Rockwell has that's who you said was Ms. Rockwell. I heard a different name, but that's me mishearing you. Okay.
Right, Attorney Rockwell's on the case, and she's also, been paying involved with this.
Okay. All right. Mr. Evans, anything you want to add? You don't have to say anything at all, but if there's something you think I ought to hear in connection with this situation, I'm happy to hear it.
Right now.
No? Okay. Perfectly fine. Ms. Dilligard, why don't you give me the state's perspective, please?
Yes, Judge. So the state is in agreement with probation's revocation to revoke the balance 4 years and 10 months, just due to the extent of the injuries of the victim, the victim being a law enforcement officer who is present in the courtroom today as well. The attack was caught on surveillance video. It lasted a little bit over 2 minutes long of him vigorously being beaten, stomped, punched. He had multiple injuries to his head, a lot of head trauma, leg trauma. Speaking with him earlier, he said that he was pistol whipped during the incident. And so the state's position is that we would request that the court revoke the balance due to the extent of the injuries of the victim, who the victim was. He was just there trying to keep everyone safe. He was no bothersome to anyone. He didn't deserve that incident occurring. And so that is the state's position.
Okay. Couple questions. Mr. Rigdon mentioned something about, I haven't seen the video, so I don't know the ebb and flow of the events, but Mr. Rigdon mentioned something about his client, so Xavier Evans, being so wobbly that he may even have been difficult to participate, in my words, not his, because he fell over and was sort of stumbling around. And so that if I were watching the video, what I might see is Mr. Evans's brother being the primary aggressor. Do you feel that that's what the video shows, or not so much?
I think that not so much. I believe that Mr. Evans threw the first punch. He did stumble after, landed on the ground, but he did get back up and continue the assault. There was even a point where the brother walks away and he's continuously stomping and punching, and what the victim says, also hitting him with a firearm as well.
Okay. Well, that gets into that second area, because I don't think, I mean, it's not indicted yet, but the firearm piece has elicited a lot of squints from both Mr. Evans and his lawyer. And again, I haven't seen the video. You have. Is there some point where you could look at it and say, there's a Glock in his hand and he's hitting him on the head with it?
It's not very clear to me, and I didn't really notice it until speaking with the victim earlier today. You see him reach in his pocket. Victim says that the firearm dropped to the ground. He was able to pick it up, and you can see him like making this movement, but it wasn't very clear to me what was in his arm at that moment. But it would take some further research and investigating.
But no allegation that shots were fired.
No allegations.
Not that it makes this any less serious, but it was a beating with hands and maybe something in the hand.
That is correct, Judge.
Okay. Hold on, I'll come back to you guys. Any firearm recovered? I don't know if the two gentlemen were arrested at the scene or they beat this guy silly and they take off, and so they're identified through the video and
they take off. And so nothing in my initial report mentions a firearm recovered. Okay.
All right. Can you give me the last name of the victim?
Yes. Last name is Cheers, Cheers.
All right. And Mr. Cheers is here?
He is, Judge.
Okay. Have you asked Mr. Cheers if he wants to be heard at all?
He does not wish to. He was here in case we did move forward with the evidentiary hearing.
Got it. Okay. He would be an important witness.
Yes, Judge.
Got it. And Mr. Cheers is a Fulton County deputy, an Atlanta police officer?
Fulton County.
Okay. Got it. All right. Well, Mr. Cheers, I appreciate you being here. You've got a right to be here and you had a right to be heard, but there's nothing wrong with saying nothing as well. So we'll leave it at that. Anything else on behalf of the state?
Nothing further from the state, Judge.
All right. Mr. Rigdon, I know you wanted to add something,
Sure.
but I'll pivot back to you.
Sure, Judge. Obviously, the allegations of filing are new to us since it's new to the state. I know that just in Wishburne, in my ear, he denies that any firearm was used or was even there. I'd also like to point, Judge, that sometime fairly before all this happened, he had his long-term romantic partner was pregnant, and that baby was born and and expired, Judge. So that may have gone into some of the mental turmoil that would have led to, I guess, the offender and such portion.
Sure. All right. Ms. Simpson, anything in Mr. Evans's, I'm gonna call it probation file, but it's scribe or whatever your system is, showing that there were other issues while Mr. Evans was on probation? He'd been on probation for a while. And I'm curious if this is the first situation we've had, or if there were other revocations.
He is flagged in our system as a repeat offender.
Okay. But repeat offender says to me that he's got a criminal history. That might explain why some of the people are here in court. But my question was,
He has not been revoked on this.
okay, his record on probation in this case until now was not problematic.
No.
Okay. All right.
Judge, I would like to add, it's not on this petition, but he does have another open unindicted case.
The
for
entering auto?
The entering auto.
Okay,
yes.
there were two PI numbers on the calendar. I thought one might be his brother. I was trying to pull up his brother's case to see what its status was, but it's one of the cases on the calendar is this case, unindicted, and the other is some entering auto.
We inquired about looping that in on this, and we just weren't able to make it happen, Judge.
Okay. So there was, I don't know what's in your system, Ms. Simpson, but I'm looking in the docket and way down here in December of 23, I signed an order revoking Mr. Evans's probation because for 30 days because he in February of 23, you see it now? Okay.
It was in a different folder.
It was in a what?
A different folder.
Oh, all right. Well, make sure you check the different folder next time too. But there was some incident in February of 23, new offense, fleeing and attempting to elude, discharging a firearm on a public highway or on a street, reckless conduct. Anyway, that case resulted in a revocation in this case. All right, got it. Mr. Evans, tell me a little bit about the need for drug or alcohol treatment. Your lawyer said, you know, one thing we ought to be thinking about is getting Mr. Evans some help on that front. What would that be all about?
Your Honor, how you doing?
Doing okay.
All right. But lately I've been drinking a little too much. A little too much.
Okay. But lately, meaning this isn't something that's been going on for years, it's more recent?
But a couple of years. Since like 2023.
Okay, what happened in 2023?
Just life.
Just life?
Yeah.
Okay.
Drank a little too much.
Okay. All right. Did you have anything else, Ms. Dilligard, or you were just still standing?
Just standing still.
Okay.
Sorry.
That's all right. I get input from Ms. Jackson. Good afternoon, Ms. Jackson. I haven't seen you in a minute.
Good afternoon, Your Honor.
Can you share with me the criminal history for Mr. Evans?
Yes, Your Honor. He has 12 cycles. The last arrest was February the 16th, 2024 in Barrow County, Georgia, for 5 counts of theft by taking, a felony. There's no disposition for that. He does appear to be on probation in Fulton County for burglary. That case number is 19 SC 170465. That disposition date was January the 13th, 2020, and the term is for 7 years. He does have a prior felony conviction that was in 2016 for entering an automobile. And he does have a misdemeanor sentence. So in 2023, received a nolo contendere sentence for affixing material that reduced or increased light transmission. Nothing in addition, Your Honor.
All right, thank you. Okay. So, Mr. Evans, it was helpful to hear from everyone involved. Whether it was alcohol or some of the grief you were feeling over the loss of your child or a combination thereof, those things might explain why you did what you did. But of course, they don't justify it. They don't make this situation any less traumatic or difficult for Mr. Cheers. It sounds like this was, it may not have seemed unprovoked to you at the time. Don't know how you were perceiving things, but we had someone who in an off-duty capacity was just providing security at a convenience store. And for whatever reason, you and your brother lost it with this guy and beat him pretty seriously. I don't need to resolve the was there a gun or not. The seriousness was just the nature and extent of the beating. You're not charged with using a gun in an offensive way. That may be how the case evolves, because presumably someday the state will indict you. But as I weigh how serious this was, being on probation, this would be your second revocation on this case. I noticed in the sentencing that I did for the burglary case, that sentence was to run concurrently with not one, but two other felonies you had in Fulton County. You had some revocations in those cases. You have been having trouble staying out of the way of law enforcement for a while now. And this particular situation seems to be one where we had an officer minding his own business, and it's one thing to mouth off, and it's another thing to start beating the guy up. And we all need to take that real seriously. I know I do. That's not the way to manage that kind of situation. So I find that you have violated the terms of your probation and the conditions of your probation by being arrested for aggravated assault and aggravated battery. I am going to revoke 4 years of your probation and reinstate the balance. It will be a special condition of your probation that you submit to a drug and alcohol abuse evaluation when you are released, whether that's by way of parole or when your sentence expires. And if there's any treatment recommended, that treatment will become part of your probation. I think drug court might make sense. It wouldn't make sense right now because of the pending charges. That case needs to, it sounds like you've got two cases, but in particular, the assault on Officer Cheers, Deputy Cheers, that case will need to be resolved before an option like an accountability court would make sense. But more importantly, you'd need to get through this revocation. You'll get credit for all the time you have served, and I suspect whatever judge ends up getting assigned to your case you have with your brother that involves the assault on Deputy Cheers, that judge will see that there has already been a penalty imposed for what happened to, what you did to Deputy Cheers. It doesn't mean that it would be exactly the same sentence, but this will likely go a long ways towards what your ultimate sentence is for that new charge. And your other new case entering auto, I think will just sort of follow naturally along. But I'm not going to, if I'm the judge on those cases, that's purely coincidental. It will be randomly assigned to one of the judges. It doesn't automatically come to me because I had your burglary case. That case is closed out. And so these new cases will be assigned wherever they go. Anything else, Ms. Simpson, on behalf of DCS that you need to complete a revocation order?
No, just that, on the record, he needs to report in 48 hours and his release back to his, original science law.
Right. Ms. Dilligard, anything else?
Nothing further from the state judge.
All right, Mr. Rigdon, anything else?
Yes, Judge, we just asked that he be allowed to serve some of this time locally. I know Attorney Rockwell's requested it, I'm requesting it. He does have these multiple cases going on, and it's going to become very complicated if he's shipped down the road, Judge. Okay,
well, I will consult with the sheriff on that and see how he wants to manage it, but I will certainly express your client's preference. I want to hear that from you, not because I doubt Mr. Rigdon, but it's one thing that it's easier for Ms. Rockwell to have you around. It's another thing for someone who is staying at Rice Street to say, I would rather be at Rice Street than in a DOC facility.
Right.
You would rather be here in the county jail?
Yes, sir.
Okay, good to hear. I heard you say it on the record. All right, thank you. All right.
I'm going to go see my client after that. That'll conclude my business.
All right, you'll be free to go. Thank you, everyone.